Good morning, everyone. The webinar will begin shortly. Thank you for your attendance this morning. All right, good morning, everyone. My name is Jeffrey Salant. I am the HOA Information Officer with the Division of Real Estate, which is a division of the Colorado Department of Regulatory Agencies, also known as DORA. This morning, we are going to talk about the Colorado Common Interest Ownership Act, also known by its acronym CCIOA, or frequently referred to as CCIOA, and what it says about association meetings. There are 5 handouts attached to this webinar: a PDF copy of this presentation, a PDF copy of CCIOA, a PDF copy of the Colorado Nonprofit Act, a summary of Robert's Rules of Order from the website robertsrules.org, and some tips regarding remote association meetings from a local law firm who specializes in community association law. You may download these handouts at any time during this presentation by clicking on the blue links located under the Handouts tab on the GoToWebinar control panel. Today's webinar will be recorded and uploaded to YouTube later today. Once available, you may access it via a link to the division's YouTube channel in the second to last slide on the PDF handout of this presentation. The handouts attached to this presentation will also be available on the division's YouTube channel in the comments section of the recording of this presentation. Please note that the information provided during this presentation is for educational purposes only and is not meant to provide or be construed as legal advice. Any legal questions you have should be directed to a licensed Colorado attorney. And if you have any questions which arise out of today's presentation which apply to your specific circumstances, please do reach out to your association's community association attorney. Before we get into the presentation topics, I want to take a few minutes to walk you around the HOA Information and Resource Center's website. This is our page on the division's website. It is located at dre.colorado.gov/HOA-center. There are 6 main subpages to our page. The first is Register Your HOA. Great information here about registering and renewing your HOA. Some links on the right-hand side that'll take you right to where you need to go if you'd like to register or renew your HOA, or if you'd like to download a list of registered HOAs. Some troubleshooting commonly asked questions down here. Next is our HOA forums page. Gives you some information about upcoming forums. Little infographic here about today's and the next couple. We have one coming up on October 7th regarding how to handle HOA disputes. And then sometime in November, we will have a date and time shortly for you. The HOA Information Office will be partnering with the Civil Rights Division for a discussion on Colorado's fair housing laws and HOAs. There's a great link to our calendar here. You can click on any upcoming events in order to register. If you'd like to file a complaint with the HOA Information Office, you may do so by clicking on the File a Complaint icon. As many of you are aware, there is no regulatory oversight of HOAs or community association managers in the state of Colorado. However, the HOA Information Office does accept complaints against HOAs and community association managers, and we take those complaints and itemize them for the issues and concerns therein. We enter them into a statistical database, which is later used to compile an annual report. This annual report is very important. It gives members of the public as well as the state legislature an idea of what we're seeing in terms of issues and concerns related to HOAs. So you may do that, and on this page you can click here to file a complaint. If you'd like to just download the form, you can do that here. Next is board member education, arguably one of our most valuable subpages. We have a list of nearly a dozen, if not more, topics, short videos that you can watch. Obviously, great resource for board members, also a great resource for HOA members so that you understand the rights and responsibilities and roles of board members. Take some time and scroll through here. Next is our homeowner toolkit. It's a great resource for potential new homeowners in an HOA, as well as existing HOA members. There's a short test here you can take to see what your knowledge base is on HOA law. Great publication regarding what to know before you purchase in an HOA. We have a couple of previously recorded forums regarding HOA state law and governing documents. Some more information regarding HOA homeownership for new homeowners and additional resources for HOA members. And finally, we have our resources page, which kind of amalgamates all of the information I just showed you, points to some of the more frequently used areas of the website. And then down here, after it loads, we have our HOA resource database, which is a listing of all of our resources and information. There's a total of 74, so you feel free to scroll through them down here with this arrow. You can also do a keyword search. So for example, if you are looking for information regarding the Colorado Common Interest Ownership Act, you would start typing in, Colorado Common, and boom, we have a copy of the Colorado Common Interest Ownership Act, and it also looks like we have some specific sections of interest here as well. So take a look at here, this page, there's a lot of great information here. I'd like to take just a moment and review the role of the HOA Information and Resource Center. What the HOA Information and Resource Center does is we provide information to homeowners regarding their basic rights and responsibilities under the Colorado Common Interest Ownership Act. Again, we call it CCIOA. We gather, analyze, and report information through complaints and HOA registrations. We create resource materials and provide education forums. We provide a website with information for the public. We register HOAs pursuant to the statutes. We provide an annual report to the legislature. What we do not do is we are not a regulatory program. Again, there is no regulatory oversight of HOAs or community association managers in the state of Colorado. We do not mediate or arbitrate. We may not provide legal advice. We do not act as an advocate or assess fines or penalties, and we may not enforce an HOA's failure to register. We have been getting quite a bit of inquiries regarding how to handle annual meetings during the pandemic. And what I can tell you is, in general, HOAs do have the right to hold a remote meeting unless it is restricted in its governing documents. I will note there's been a lot of questions asking whether or not there have been any executive orders or emergency bills regarding CCIOA and its requirement that you hold an annual meeting of the membership. There have not been any executive orders or emergency bills regarding this, so CCIOA does stand as unamended as it was previous to the pandemic. What I have done is attached additional information regarding concerns and considerations for holding online meetings. Again, this is from a local law firm who specializes in community association law. Please be sure to consult with your community association attorney if you have any additional questions. The process and manner in which each individual HOA holds their annual meetings is going to differ slightly depending on their governing documents. So in addition to taking a look to the information provided today, please do consult with your community association attorney. Okay, today's presentation will go over the requirements in CCIOA regarding association meetings. Generally speaking, there are three types of meetings in a homeowners association. You have meetings of the unit owners, board meetings, and special meetings. Section 38-33.3-308 subsection 1 of CCIOA addresses the frequency with which association meetings should and may take place. Regarding meetings of the unit owners, CCIOA only requires that they meet once per year. This is commonly referred to as an annual meeting. It is at this meeting that many HOAs will plan their budget ratification. Some may also schedule any elections for board member roles that may be opening up. This section of CCIOA also prescribes how special meetings of the unit owners may be called by the president of the board, a majority of the members of the executive board, or by unit owners having 20% or any lower percentage specified in the bylaws of the votes in the association. Special meetings may be called for a variety of reasons, including but not limited to such purposes as removing directors, voting in new directors, or just to discuss a particular issue. Although CCIOA does not specifically address the procedure for when and how to call board meetings, you will likely find this information addressed in your association's governing documents. Since board meetings are for the discussion and deliberation of matters affecting the association for which the board is responsible, the frequency of them will likely be determined by the members of the board. Section 38-33.3-301 subsection 1 of CCIOA goes on to discuss the notice requirements for the meeting of the membership. The requirements state that the secretary or other executive board members specified by the bylaws provide notice to each unit owner of any meeting of the membership no less than 10 days and no more than 15 days prior to the meeting. In addition to hand delivering the notice or sending by mail, to the extent it is feasible and practicable, the association is also required to post the notice in a conspicuous place. The notice is required to include the time and place of the meeting, as well as the items on the agenda, while also including the general nature of any proposed amendment to the declaration or bylaws, any budget changes, and any proposal to remove an officer or member of the executive board. Interestingly, CCIOA does not contain a requirement that members be given notice of board meetings, but again, the association governing documents may. In the same section of CCIOA, but the next subsection, subsection 2, CCIOA discusses the allowance of attendees at meetings, along with an encouragement to provide notices electronically. It states that all regular and special meetings of the executive board, as well as any committee, must be open to attendance by all members of the association. Members may also designate a representative to attend for them. While this presentation will not cover the processes for creating a representative relationship, if you are expecting your designated representative to appear at a meeting of your association on your behalf and foresee any issues arising from such, be sure to reach out to your board or management company far enough in advance of the meeting to ensure you have time to accommodate any additional steps your association may require when informing them of your designee. While an HOA may not prohibit your designated representative from appearing on your behalf, They may have a policy regarding the manner in which you must inform them of such first. This section also encourages associations to provide all required notices and agendas in electronic form. If the association has the means to do so, they must provide notice of all regular and special meetings of the unit owners by mail to all unit owners who have provided their email addresses and who have requested to receive notices via email. Email notice of a special meeting must be given as soon as possible, but at least 24 hours before the meeting. As discussed in the last slide, CCIOA does not contain a requirement that members be given notices of board meetings. However, an association is required to make agendas for meetings of the executive board, quote, reasonably available for examination. Unfortunately, the term reasonably available is not defined. In subsection 2.5 of section 308 of CCIOA, CCIOA goes on to specifically clarify the allowance of attendance mentioned in the previous section. It states that despite anything in the association's governing documents which may be to the contrary, all meetings of the association and board of directors are open to every unit owner of the association or to any person designated by a unit owner in writing as the unit owner's representative. It is this language regarding a designation of representation be in writing which you should be concerned with if you plan on having a representative appear on your behalf. Colorado's HOAs have a significant amount of out-of-state members, and many may wish to have someone attend a meeting on their behalf, which is why taking some time before a meeting to ensure that the association is properly informed of a designee attendee is so important. This section also discusses the protocol for member participation in meetings. It states that unit owners or their designated representatives must be allowed to speak on an issue before the board votes on it. However, the board may determine the appropriate time for doing so and may also place reasonable time restrictions on persons speaking. Additionally, if more than one person wishes to speak on an issue and there are opposing views, the board must provide a reasonable number of persons to speak on each side of the issue. Again, CCIOA gives the board broad discretion in making such decisions and unfortunately does not define what a reasonable amount of time is. Section 38-33.3-308 subsection 3 of CCIOA discusses executive sessions of the board or any committee. During these closed-door executive sessions held by the board or any committee, the board or committee may restrict attendance to only the board members or committee members and any other persons requested by the board or committee. However, these closed-door executive sessions of either the board and/or committee may only be held for the discussion of specific matters which are subsequently enumerated in CCIOA. Section 38-33.3-308 subsection 4 of CCIOA lists the acceptable topics for executive session discussion. They include matters pertaining to association employees or the managing agent's contract, consultation with legal counsel on a pending matter or other matters which are protected by attorney-client privilege, or the review of or discussion related to any communication from legal counsel, investigative matters concerning possible or actual criminal conduct, matters subjected to protection from public disclosure by law, and any other matter the disclosure of which would constitute an unwarranted invasion of individual privacy. Sections 38-33.3, 308, 5, 6, and 7 of CCIOA provide additional requirements regarding executive sessions. Prior to the convening of an executive session, the chair of the convening party must announce the general matter of discussion as enumerated in subsection 4, as previously discussed. No rule or regulation may be adopted during an executive session, and the minutes of all meetings wherein an executive session was held must indicate that an executive session was entered into and the general subject matter to which it pertained. This means that if during a regular board meeting, the board entered into an executive session to discuss a pending legal matter, the minutes from that board meeting should indicate at what point during the meeting of the board they entered into an executive session and that they did so in order to discuss pending legal matters. This requirement should not be confused to mean that there must be minutes of the executive session itself, which would negate the confidential aspect of such a session. While there are generally only 3 types of formal meetings, another form of conference commonly found in HOAs are working sessions. Although not specifically defined in CCIOA, work or study sessions of executive boards are not prohibited by it. However, they still must be in accordance with the community's governing documents and policies. Since they are not considered meetings due to the lack of actions or votes on community issues, unless otherwise stated in the governing documents, unit owners do not have a right to notice of the session or a right to participate, and minutes are not required to be taken. Section 38-33.3-309 of CCIOA discusses the requirements regarding quorums. Oxford Dictionary defines quorum as the minimum number of members of an assembly that must be present at any of the meetings to make the proceedings of that meeting valid. The specific requirements for quorum will first be found in the association's governing documents. If the governing documents are silent on quorum requirements, a quorum is deemed present through any meeting of the association if persons entitled to cast 20%, or in the case of an association with over 1,000 units, 10% of the votes which may be cast for election of the executive board are present in person or by proxy at the beginning of the meeting. It is important to recognize that since CCIOA allows proxy votes to count as physically present, although a meeting may not appear to have enough bodies to amount to a quorum, if enough proxies have been executed, there still may be a quorum. If the governing documents are silent on quorum requirements, a quorum is deemed present throughout any meeting of the executive board if persons entitled to cast 50% of the votes on that board are present at the beginning of the meeting or have properly executed their proxy. The Nonprofit Act is an additional piece of legislation which may also govern an association if it is organized as a nonprofit corporation, which in Colorado, most HOAs are. Anytime a section of the Nonprofit Act conflicts with CCIOA, CCIOA will generally control. If you have any questions regarding conflicting sections of the law, it is important to address them with a licensed Colorado attorney to determine the applicability to your specific circumstances. The Nonprofit Act does touch on meetings of a nonprofit corporation, but many of the sections are duplicative of those in CCIOA. Therefore, today's presentation will not dive into the Nonprofit Act beyond mentioning it. Neither CCIOA or the Nonprofit Act drill down into the specific requirements regarding minutes of association meetings, association minutes. You should look to your association's governing documents to determine if there are any requirements regarding meeting minutes which are specific to your association. As a very general rule, minutes should contain the following: the name of the association, the date, place, and time of the meeting, the statutory or bylaw authority under which the meeting is called and whether it is a regular or special meeting, the persons present and/or the persons absent, or the members or directors represented in person or by proxy, depending on what type of meeting it is, a statement that the meeting is held pursuant to actual notice or waiver of notice. If notice is waived, the signed waivers should be attached to the minutes, approval of minutes of previous meetings, the substance of the issues or actions presented at the meeting, how they were submitted and by whom, the decision or vote on each proposed matter or resolution, and in the case of substantive matters, the outcome of the votes, the presentation of all reports with copies attached if the report is written and a summary of the report if it is oral, as well as a summary of other business which came before the meeting. Additionally, as discussed a few slides back, one of the few requirements in CCIOA is that meeting minutes reflect the general topic of discussion for any executive session entered into during any meeting of the association, board, or committee thereof. Robert's Rules of Order. What is it? It is the most widely used manual of parliamentary procedure in the United States. It governs the meetings of a diverse range of organizations, including church groups, county commissions, homeowners associations, nonprofit associations, professional societies, school boards, and trade unions that have adopted it as their parliamentary authority. The manual was first published in 1876 by U.S. Army officer Henry Martin Robert, who adopted the rules and practice of Congress to the needs of non-legislative societies. If any of you have ever participated in a fraternity or sorority in college, Robert's Rules of Order may be familiar to you, as its processes are frequently used in those organizations as well. How is it helpful? Robert's Rules of Order were developed to ensure that meetings are fair, efficient, democratic, and orderly. A studied chairperson allows all members to voice their opinions in an orderly manner so that everyone in the meeting can hear and be heard. It is a time-tested method of conducting business at meetings and public gatherings and can be adapted to fit the needs of any organization. A summary of the Robert's Rules of Order from robertsrules.org is attached to this presentation. While every community is different and will benefit from different methods of practice, there are some common elements to most association meetings that, if addressed properly, can certainly lend to a smoother, more productive meeting for everyone. For board or committee members, it is important to remember that you may likely be confronted with challenging questions. Consider brainstorming difficult issues that may arise during the meeting and writing up some notes to help you respond. Time management is essential in association meetings. Utilizing and following a well-drafted agenda can make a tremendous difference. Reviewing and posting your association's conduct of meetings policy prior to a meeting will allow you and attendees to understand what behavior is acceptable and which is not. Finally, if it is known that the meeting will include the discussion of a topic which the board or committee is unfamiliar, consider inviting the appropriate expert to be on hand to speak or answer any questions. Typically, this would be an accountant or attorney to address a financial or legal issue. Dealing with disruptive behavior at meetings of an association is an unfortunate reality that many associations will encounter. The best practice to avoid disruptive behavior is to maintain protocol. This will involve adopting a procedure for conducting meetings in order to cut short obnoxious and disruptive behavior. Be sure to apply strict but reasonable time limits for those who wish to speak. Utilizing a sign-up sheet for this purpose is advisable, as it provides another opportunity to communicate expectations to potential speakers. The person in charge of running the meeting should be very familiar with the association's governing documents with respect to meetings, elections, voting, proxies, etc., and should be able to speak to them. Having the association's governing documents available during a meeting in a digital searchable format so that specific sections may be easily and quickly retrieved is also advisable. Always provide fair and balanced direction to individuals who are or may become disruptive. Warnings with a specific reference to the unacceptable behavior should be given. Finally, if an association cannot conduct business due to serious and/or continued disruption from a member, the association may consider ordering him or her from the meeting. However, removal should be a last resort, and no one from the board, committee, or membership should attempt to physically remove anyone. If an attendee who has been warned and subsequently asked to leave refuses to do so, the chairperson may consider involving law enforcement. As we wrap up today's presentation, I will attempt to recap some of the more important topics discussed. Remember that while CCIOA requires notice of a meeting of the members of the association, often referred to as the annual meeting, it does not require notice of board or committee meetings, but your bylaws might, so please check your governing documents regarding this. Members of an association have a right to attend meetings of the association, also known as annual meetings, board meetings, and committee meetings, and a convening party must properly enter an executive session in order to deny admittance. Members also have a right to participate in meetings, but the board is allowed to impose reasonable time limits. When running a meeting, remember that before the board votes on an issue under discussion, unit owners or their designated representatives must be permitted to speak regarding that issue. And if more than one person wants to address an issue and there are opposing views, the board must provide for a reasonable number of persons to speak on each side of the issue.